Welcome to everybody in the room, but also to those of you online. We are so grateful to you all for joining us this evening for our conversation about neurodiversity and the bar. It is Neurodiversity Celebration Week this week, which many of you may well know. It is a worldwide initiative that challenges stereotypes and misconceptions around neurodiversity, while celebrating the unique minds of neurodivergent individuals. We are anticipating this event's going to be a dynamic one. We want to engage in a conversation with you all, be it in the room or online. And with that in mind, we have had plenty of questions submitted in advance, which we're going to attempt to answer during the course of this conversation. We anticipate the event will end by about 7 o'clock this evening. And if you are with us, then please do join us for drinks afterwards and the opportunity to speak with one another more directly. Turning now to introduce our speakers then. My name's Emma Southern. I'm a bencher at the Inn and a family practitioner. But the real stars of our show this evening are the people sat to my right. First, we have Coverley. She's called in 2014, is a specialist education, equality and public law barrister. Alice was the Times Lawyer of the Week in July 2023 and won the Legal 500 ESG 2024 award for Disability Neurodiversity Bar Champion of the Year. Adam Richardson was called in 2011 and is a barrister specialising in data protection, privacy and reputation management. He is a board member and trustee of Neurodiversity in Law Charity. And Katherine Soroya was called in 2022 and is a pupil of Julian Norman at Goldsmiths Chambers. Julian was due to join us this evening, but is unable to do so. And we welcome wholeheartedly Katherine's knowledge and assistance today, particularly with pupillage and navigating those systems. I've referenced Julian Norman, who we had advertised as a speaker. Whilst she can't be here today, she has very kindly provided a video, which we will share with you in due course, particularly about sitting part-time in the judiciary and the impact of associations in that respect. She was called in 2012, previously a solicitor and specialises in immigration law. Her judicial career, it relates to being a family recorder on the South East Circuit, a deputy district judge and a fixed fee paid judge of the tribunal. So those are the introductions. I think we're going to first turn on to the questions that we've been asked. And Alice, if you want to kick us off with one that's particularly caught your eye and begin our conversation.
Awesome. Hello, so I'm Coverley. I've got ADHD and sensory processing difficulties. I was diagnosed like 3 years ago now when my son was about 5 months old. So quite a lot of the time mothers work out that they have ADHD after the pressures of being a parent are on top of them, as well as being a barrister. So that's a bit about me as well. One of the questions here is about how do you ask for reasonable adjustments when your clerks don't understand ADHD and the challenges that come with that. And I thought I would share like how I spoke to my clerks after I got my diagnosis and which particular clerks I talked to about it. So I'm at 3PB, it's a really large set. We're probably one of the largest. I think the others probably second largest in the country. So we're pretty unusual in that we have quite a huge clerking team. And so I had to make a decision that I didn't need to tell every single clerk because I would probably not come into contact with all of them. But I did have a more tight team of about 3 or 4 clerks and a senior clerk who managed them, who did need to know. And the reason why I thought it would be helpful for them to know is actually because in my day-to-day practice, I'm working directly with my clerks every day, and I'm communicating with them every day about my diary, about my workload, about inquiries that come in. And so it was particularly important for me to share, not only was being a parent difficult, but also it was extra difficult because I had worked out that all this time I also had ADHD. And so for me, being able to talk to them was amazing. I sat down with them and I'm really grateful to them because they were just amazing about it. And I said, I've got ADHD, this is what it means. This is also how I think there are some adaptations that could work, that really work for me. And actually you're already doing them because you've already worked me out, because I've been in chambers by that point 6 years. Now nearly 10, and they had already started to work out that I preferred particular ways of doing things or needed particular reminders and stuff. So one particular example was clerks often call you. That's generally speaking how clerks will communicate. They'll call you at random at any point of the day and be like, this solicitor wants this, or have you seen this email, or new instructions come in, or whatever. And it wasn't so much that I minded being called on the phone. I know for some people that would be particularly problematic. It was more that that phone call would interrupt what I was doing and derail my progress in that particular task. And I would happily have a half an hour conversation with my clerk rather than doing the work that I needed. And I would also often actually not necessarily want to deal with the thing that they were calling me about and hadn't actually had time to think about it yet. So being asked about it on the phone wasn't very productive because I'd still have to think about it, and I needed the time on my own to do that, not on the phone, with the pressure of being on the phone. So now all of them email me unless it's absolutely urgent that they need to call me. And it's really rare that anyone calls me. And a new clerk today from Bristol called me and I said, just so you know, this is the way it works. And they were amazing. They're like, cool, I don't care. This is what you need to know. This is what I was calling you about. And that's fine. Other people won't respond as well to email reminders of stuff, whereas I do. If I get a regular reminder from my clerks about billing or about, you need to reply to this, I now don't take it as a criticism. I just see it as a neutral thing and as a reminder. So my number one thing is that clerks are actually much more understanding than I anticipated. They're normal people. They're in society like us. They've heard of these conditions in the same way. If you tell them what your needs are, and if you talk to them about how you can help them to better do their job in communicating with you, talking to the clerks, talking to clients, talking to other solicitors, that helps them. And I've just, if you haven't digested what I've said already, I have just written all about this for one of our blogs for neurodiversity in law about how to talk to your clerks. So that would be my advice on reasonable adjustments and clerks.
That's great. And being open, I suppose, to that, having that conversation. Did you want to add to that, Adam?
Sure, just a little bit to say, it's just piggybacking on what you've said, frankly, that don't be afraid to actually say what it is you need to your clerks. It seems a bit obvious, but I, for the largest part of my career, was just terrified that if I annoyed a clerk, I'd get no more work and that was the end of me. And then when I had a more open and firm dialogue with them, then no one was trying to do one over on me or make me do something I didn't want to. We were all part of a team. And I was much more cohesive about it. So I think if you could just start that dialogue and keep it within the realms of rationality and in a friendly space, you'll probably get there. And you needn't be terrified of your clerks, I can confirm.
And from a pupil's perspective, I suppose your interactions with the clerks have been relatively limited in comparison to those who've got tenancy. But have you been open with the clerks in terms of any neurodiversity that you identify and how best to?
Actually, I haven't, but I would feel very comfortable doing so because whatever works the best for me in my approach is really going to help them to understand. So we haven't spoken about it yet, but it's not something I'm deliberately avoiding speaking about. Yeah.
I suppose one of the best things about the bar is there's such a mix of people. We are all individuals. We're all driving our own practices to some extent, and we all need adaptations. And having those open conversations about whatever it is in life, be it caring responsibilities or other features in our life, having that conversation and overcoming that first hurdle means that adaptations can be made.
Yeah, I completely agree with that. I mean, there'll be certain barristers who don't necessarily want to be the top 1% of all barristers in the world. They just kind of want to go to court and come home and, to quote one of our barrister members who I won't name, go home and sit in your pants, read a book. Like, you don't want to be the best one in the world. You just want to do that. And then it's also okay to be like that, be a normal barrister. You're already like at this career, which is already high stress and a very prestigious role to be in. And just doing that is awesome. So that I thought was some helpful advice I got very early on in my tenancy, that if you want to do that, that's fine too.
So what about diary management? How do you guys handle that, or what top tips do you have in that respect?
So diary management was really what was my lead into the conversation with the clerks. Because so I'm Adam Richardson as well. Sorry, bit of a preface. I was diagnosed dyslexic at a very young age. A lot of it was just coming to terms with what that means for me, and it was later on that I actually disclosed that to anyone at the bar. But now I'm very open about that and pro disclosure, but I'll get into it. It was diary management with the clerks that had me worried. I thought, because I have an older brother at the bar and he has a very different approach to things, and he told me all sorts of scare stories, as older brothers do, that I believed about the nature of work and the politics within chambers. But I took every piece of work that was going. Like, if something needed doing, I wanted to be the go-to guy. I wanted to get in everyone's good books, all of which ended up just burnout after burnout after burnout. Until eventually I learned a really useful word in these scenarios, which was no. And sometimes that's okay, because the clerks will manage your diary for you, and they will put work in if they can. But if you're very clear about it, and if you make your boundaries clear, because they want to get the best you as well, that what's good for them is also good for you. If you're the best barrister and you're doing the best work and get repeat business, that's good for the whole operation. So no one wants to overstretch you. And I find that being realistic about what you actually can take on, including recovery time, depending on what your neurodivergence may be, or how you respond to the high stress situations that court can bring, I find is very useful. And as a result of that, I think that you just have to be realistic about what you can do and how much you might need to recover from it, and plan accordingly, rather than it's very easy to fall behind and play catch up in this job. And I think trying to take a beat to know where you're at, to check in with yourself, and to communicate that with your clerks, and have an ongoing feedback relationship. I think that's very helpful in terms of diary management, certainly for me.
I think for me, I will often say yes, because I think something is really interesting and exciting. So I've had a rule when I need it, when I know that I'm on that kind of hype curve into crash, that I tell the clerks, don't even tell me about the call instruction, because I'll say yes, even though I can't do it. And I think that's another type of no. It's don't tempt me, is something else I would say is helpful. And the other is, bear in mind that most of the bar goes on holiday in August. I take a good 5 weeks off in August. Is the best thing I've ever done. I'm a bit more senior now and I can do that, but it's so important to me. I spend a good 2 weeks just staring at a wall because I need that time to recover. And that recovery time is absolutely essential.
Recovery time is one of the questions that we've been asked about, specifically in relation to social interactions and the need to work independently in a quiet space after having significant social interactions. How do you navigate that? What examples have you got where that's worked well, or where you haven't been able to have that quiet space?
I think as a pupil, it's a uniquely challenging, interesting, exciting position, because when you're observing in court, you're not actually doing the advocacy. So you're there, present, following, ready to answer questions or pick up drafting, but you're not able to speak to the judge, which can be infuriating if you have ADHD and you're passionate about an area of law and you really want to say what you think should be said. You're also managing all of the difficulties of being in a courtroom if you have sensory problems, the weird temperatures of courts that we're all familiar with, the weird lighting, whether the judge decides that day they want to sit through lunch, which has happened a few times, which is also my worst nightmare. So it's definitely a unique area where having that time and being able to decompress is really important. And as a pupil, I think sometimes we forget we have an ability to express a need to do that. And I would really encourage people to do that. So originally, I was expected in court 5 days a week. I think doesn't always realistically reflect what a barrister's diary might look like. So pretty early on, because of my self-awareness about how these things would burn me out, I could speak to my supervisor and suggest a day a week. We aimed for a day a week where it would be a paperwork day, which is a realistic reflection of what life at the bar might be like for someone. And the reason I requested that is because I know at home I can control my environment and I can recoup some of that energy that I've lost, and I can really focus on some of my other interests, which are drafting, for example. So I think being self-aware enough to know what you need to be able to have that conversation with a supervisor is quite important, because they may simply be unaware because often people are very good at masking what they actually need. And just drawing attention to it has really helped. And it means when I am in court, I'm of more use to people I'm following anyway, because I've got far more energy to pick up drafting orders or things like that. So it is very tricky, but I think self-awareness is probably key.
And identifying that balance and almost putting in force that balance yourself, leading that balance process to make sure that you can be at your best when you're in court. And okay, that leads a little bit into one of the other topics that we wanted to discuss, which was time management, which is another mad balancing exercise for everybody. But what top tips do you have in that respect? Silence.
It's well, the problem is something is not going to talk as if I have any idea about how to really do this. It's around about 13 years at the bar, and I'm still struggling with time management. I think it's partly baked into the nature of the beast, but there are things you can do at the outsides, which are book days off in advance, knowing like far in advance, because the classic thing is you've got a week in court and you think, okay, it's just a trial. Then a solicitor wants something, so it's just a trial, and maybe it's a bit of drafting on top of that. Then you've got to book in a conference, and before you know it, some case that you had months ago has come back, and that's in the fray. I find it very hard to balance all those things, unless I've taken like a hard limit. So I put in my diary some time off or some time out that nothing will go into, and I know that can be mine to recoup from. So maybe that's my way of doing it, but I'm just not particularly great at time management at the best of times. So my only strategy is to take it out in whole rather than try to discipline myself.
I was going to add something about the type of work that many barristers look at, which I would describe as like boomerang work. So you've sent it off and you think it's gone forever. It hasn't. It will come back at random and whack you around the head when you don't need that work on that day. And it can be quite difficult to work out how to manage your time in circumstances where you've suddenly got something urgent that dislodges everything else. And I think it's just, first of all, being mindful that a lot of what we do will involve boomerang work, and building in some time in your week to try and deal with that, or having a system for, even if something really urgent comes in, is it something you can deal with immediately, like within 10 minutes? And if it's more than 10 or 15 minutes, then you have to park it and you have to diarise it for another point in the day or the week. Sometimes also things can be dealt with more quickly just by a quick phone call than an email or a bit of advice. And also don't forget that sometimes that boomerang work can also be something you can charge for. So that gives you sometimes a bit of time. You can say, Clark, actually, this is going to take me a good hour and we haven't budgeted for that with the solicitor. So can you go and agree a fee? That helps buy you some time. And that can be really useful. The other thing is, and this may be since I had children, but I'm bookending the day because I have to do the school run at the start and the end of the day. And so I have to finish. I used to work into the night like many people do. And because I really like what I do, I like carry on working. I want to carry on working. But now that I have to stop and I have to look after the babies, I find that quite useful. So I don't know if it's about having like a class or something that you specifically do at 6 or 7 or something every night or every other night. That can really help like bookend your day. And then if you've got ADHD, also knowing you've got that time deadline, like I know I have to leave the house at 5 to get my son, otherwise I get fined. So it's really useful to have that boundary imposed by something else external to you.
Yeah, I was going to pick up on the idea that a phone call is sometimes heads off about 10 emails, doesn't it? So that's something that I much prefer often. It reduce the amount of emails you need to send. Actually find with how ADHD works for me is that my time management with important deadlines is very good. I love the pressure of the deadline and I will always hit it. Anytime pressures outside of work life, can't do it. But because I really care, it means I can hit those deadlines. But I think it's really important with ADHD, because you get into these hyper focuses with things you're working on, you can forget to drink water, you can forget to eat, you can forget to wash, you can forget to walk your dog. It's really important to maybe set a little alarm that reminds you, go outside, take a step away from this, because that reduces the crash on the other side. So yeah, having that system in place and planning as much as possible, which isn't really intuitive for someone with ADHD. The idea of planning can be quite challenging, but it really helps future you.
And having that time away from work.
Mhm.
So Alice described bookending, but going to a class or a walk or
Mhm.
walking a dog or something like that, to have that time away from work. And I suppose to actually have that headspace to think through the plans that you need to make in order to navigate the coming days.
Exactly.
I would suggest like leaving your phone at home on those walks as well.
Yes.
Like nothing bad is going to happen in 15 minutes if you go to the shop and come
Mhm.
back. Like they will, even if someone has died, honestly, they will call you back. You'll be fine. Like take 15 minutes to yourself and stop looking at your phone if
Mm.
that's something you do, because you won't be able to get that headspace. I'm still learning that myself.
Me too.
It's really important.
Okay, looking at reasonable adjustments in the courtroom or the tribunal room, or if you're on an online hearing as well, there's been a lot of queries and questions around that. And I suppose my initial view about that is it's quite difficult if you're an advocate and not the person controlling the courtroom, i.e. the judge. How do you navigate that? What adaptations can you request? Should you request? Have you requested?
That's really interesting because I don't have any experience of either me disclosing or any of my opponents disclosing their own neurodivergence in court. But I have had experience of working parents saying, I've got to be done for childcare, and that's really normalised. And that's, I would say that happens almost every time I'm in court. There's a reminder that we need to be done by a certain time. But also I think being honest about, if you were asked, for example, to write written submissions, if it is like, don't just agree to, doing them within 24 hours. I mean, sometimes it's hard. Some judges are just annoying and don't realize that you need to like do other work. But be honest with, when you're looking at your diary and you're seeing, actually, I've got 2 more trials next week and actually I can't do it at the same time. I need another day for it, to say to the judge, I am not going to be able to do it until then. But then, say to the opponent, you can have the same amount of time in your response, so you get a week later or something, if it's not going to jeopardize like the decision making of the tribunal or the court. So I've not necessarily disclosed it, but I have tried to be honest when I'm thinking about things like written submissions at the end of a case, if that's coming, or asking for 5 minutes before doing oral submissions. I didn't ask for that today, and I'm very tired as a result. I could have done with literally 2 minutes to stand up and catch my breath before I did. And so you don't necessarily need to say I have ADHD or I am autistic or I'm in sort of mental distress and I need some time. But you can just ask for the time. And usually judges, I'm mostly online and in a space I work with mainly disabled children. So neurodivergence is quite a central theme. So it's generally well understood. But I have judges who go through lunch who are not mindful of their own needs. And then at 3 o'clock, like, oh, I've got a migraine. And I'm like, yeah, you haven't had lunch, which happened to me last week and it was really annoying. So yeah.
I've also never really asked for a reasonable adjustment. The thing I once asked for a break to compose myself, but I think that's because I was just generally flustered. But as Alice says, you don't necessarily have to disclose your diagnosis. I think the bench book specifically deals with judges being more understanding now about conditions that may exist that may not be visible. And I think that there's been quite a shift since when I first started to now, with judges being more receptive to this sort of thing. I mean, the thing about reasonable adjustments are that there's no prescribed list that we can point to and say, well, those are reasonable adjustments. It's what's reasonable in the circumstance, and that's dependent on who you are and what you need. It's a difficult one because you have to tell people what that is, and sometimes you may not necessarily know yourself what it is. But my advice to people is really just to be forward about it. If you know what you need and put it out there early doors, very, very unlikely you get shut down. And if you do, it really isn't what the judge should be doing. So it's a tough one and it's very individual, but there is a space for it now. And I think that's come along a long way.
I think I'll talk about reasonable adjustments in the pupillage process. So there's a number of questions about either disclosing a neurodivergence, or if you need extra time to complete tasks, what's the best way to approach this, and generally how to address neurodiversity in applications or interviews. I think the answer to that question will be incredibly personal to the person making the decision. And I think the best way for me to answer it is to say, ask yourself why you want to disclose it. Is there a purpose in you doing so? Is it something you feel very strongly needs to be included? Make that clear. I don't think there is a right or a wrong answer to the question of disclosing neurodiversity. For me, when I asked myself, why do I want to disclose this? Well, I was diagnosed very late, which means throughout all of my schooling, my university exams, when I decided to change career to become a barrister, all the GDL, all the bar course, I did that with no adjustments for sitting exams and in environments that were just not suited to me. And I thought, I don't want to suffer like that anymore. I'm going to let people know. And actually, I'm so glad that I did. In the interview process, nearly every set asked, do you want reasonable adjustments for your interview? If they didn't, I requested them, and I never met any trouble when I requested reasonable adjustments. And normally that meant just extra time. And one thing to note is that often those reasonable adjustments, in fact, I think they should never be disclosed to the panel, or in all the interviews I had, the panel weren't aware of me having any extra time or things like that. And I found it incredibly beneficial to take that extra time to help me perform in the best way possible. So that's in preparation for the interviews, but even during the interviews, again, if you've decided in yourself that maybe you'd like to talk about it, it can really help steer a conversation in an interview, or sometimes even take control of an interview in a way that shows you'd be a very competent advocate. So I found in interviews, people often don't ask what they actually mean, or they'll ask many compound questions, or they'll be expecting you to really expand on an answer, but they've asked you a very closed question. That was something which I had to learn because I took questions so literally. Having disclosed the ADHD, I felt that I could say if I didn't understand a question, I'm not clear completely about what you're trying to get from me, can you prompt me further? And in those instances, the panel sit back and say, oh, maybe we haven't been clear, and it starts a conversation. You fully understand what's being sought of you. And that's really how you'd be in a courtroom as well. So yeah, I think it's really a personal question. Why do you want to disclose it? If there's a reason that you feel strongly about, or it might help you in those situations, then go for it. And I certainly don't feel it's hindered my ability to get pupillage offers.
That is fantastic to hear. And I think those adjustments in pupillage setting, or more so in the courtroom or tribunal setting, we are so often representing clients who are vulnerable, who are overwhelmed by the process. It is entirely alien to them in any event. And so the overwhelm that we might experience for different reasons, they're experiencing for other reasons potentially. And those breaks, those 5 minutes headspace, those comfort breaks, gathering thoughts, reflective opportunities, benefit everyone, and probably the judge too.
No, that's very, very true.
Okay, do we have any questions in the room at the moment? No, no one's going to put themselves out of the stage. That's fine. Just having a look. What about here? We have someone saying, I'm constantly losing track of my notes, making poor notes, filing things in different ways and in different places, not good for my practice. How do we effectively case manage? And what systems do we have in place for gathering notes and filing our notes? Do you have any methods of working that you're happy to share that might feed into that?
I have a similar sort of problem, really. My handwriting is like a code that even I can't read. And so therefore, when I make notes, it's just the way I've learned to work because of this. I've adapted. I just sort of make notes that goes through my brain, and I can sort of remember the best. It just helps jog my memory. It seems broadly pointless for me personally to then write notes properly. But I mean, the only thing I can say that's been used to me is using a computer, using a word processor, because then you never lose track really of what it is. There can be a system, it can be chopped and changed. I think it's a lot easier than putting it to paper, but some people prefer to write because it's easier to do it that way, or it goes in that way. I think I'm not your best example for this, but I can totally empathize with the question.
What about proofreading and the like? We've had one of the questions suggests that assistance from others with proofreading documents has made a big difference to them. Is that something you've ever?
I mean, I think it's quite interesting because Word now has so much extra, like it has word prediction, it has autocorrect, the Copilot's now integrated if you've got Microsoft, Grammarly. There's lots of tools around that do help with proofreading in a way that no one would ever know. And it wouldn't be a problem that happened or was used at all. And I think there is, I think, an expectation that we are advocates both in oral sense, but also in writing, and that it is an important part of our toolbox that we are able to write fluently, clearly, and to spell check and to grammar check what we have said, but also to make sure it's not too verbose, it's got the right decisions, hitting the right points and those sorts of things. And so I don't think there's any problem necessarily with using proofreading, but I don't know if we would need a particular human to do that now, actually. I think that this talks about the kindness of proofreaders, whereas actually I think there's more than sufficient free technology out there to help with proofreading, with the massive caveat that if you chuck it straight into ChatGPT, it tends to then spit it out as very obviously from ChatGPT with bold headings and double capitalization and those long double dashes that give it away as being AI generated. So I think it's just important to remember that we've got loads of really useful tools out there and it's not a problem, and to use them because everyone is using them. I do think it's an issue.
Yeah.
It's not, it may be something you struggle with, and there's enough out there to help support that. I was just going to add as well with the paperwork stuff, some of my colleagues use Remarkably, like a handwritten, it's like a Kindle thing, iPad, but it's handwritten, and then it turns it into text and then uploads as different notes. It's like it feels like paper. I'm gonna go on my birthday and try it out, and I'll tell you about it next year if it's any good. I mean, it might be one of those kind of cool tech things that I lose and put in a drawer like my smartwatch. I don't even know where the charger is. So you have to think about what actually would work for you. And to be honest, I have tried to move away from handwriting for the same reason Adam has. Because I don't keep those notes, but I do have a notepad because it does help me to process stuff like in a hearing. I used a notepad today alongside a written word processor to record the notes of the hearing. But then down here, as opposed to my screen, was my submissions, my short points, because I knew I'd have literally 10 minutes to make a sharp closing submission. So it had to be tight. And so one piece of advice I got was to make sure that you get a nice keyboard. So I normally keyboards are like that kind of rectangular shape, but to try and get one that if you need it is comfortable for your hands, so you can just you're just absent-mindedly and do touch typing courses. Like Nessie is a really good one. You would have done them at the school, so you can just do it automatically, and every time, even if you're zoning out, you're still taking a note. The evidence can be incredibly helpful as well. So
Great.
I don't have too much to add about paperwork and managing paperwork. I think some of the administrative tasks are much harder than some of the complex legal submissions that we have to draft. So some things that have helped me are using or saving templates, so be it an attendance note or whatever template you have, and having as many of those to hand that you can amend and update. And it can prompt you when you come to it, especially if, like me, you've got a mixed practice and you're jumping between different things. If you've got a template for each of those different types of things, it can really help. Also, not putting things off, which is quite a challenge, but trying to record the time and the billing sheets as soon as the thing is done, as opposed to putting it off and then I cannot remember. And also having files organized on your computer, which are you can chuck things into and that are easily accessible. It's just if there's already the files there, you can put them in and keep it as organized as possible. So those are the few things that I've tried to do. But I imagine as my practice builds, those things will become more and more challenging.
It's a great place to start though, isn't it, to have that?
Mm-hmm.
Yeah, absolutely. And in terms of your emails, you can have multiple folders in your emails, for example, and that helps file things and you know where to find them, because it's again having that framework in place that works best for you, to be able to then, when these unpredictable occurrences happen, which they do at the bar all the time, we can manage them as best we can.
Yeah, and also just a final thing on this question,
Yeah.
which sounds like the person's being very hard on themselves
Yeah.
and doubting their skills a lot about proofreading. And I think as much as we'd like perfect drafts of everything, it's so common that there's a typo.
Yeah.
Not every document is perfectly
No matter how
written,
perfectionist you
no
are.
matter what. Yeah, exactly. So I'd also ask this person just to think about they're being a bit hard on themselves in this question.
I'm going to ask you a little bit about marketing, particularly at the self-employed bar. We're expected to market ourselves, and some people are great at marketing themselves. Often advocates are brilliant at marketing others or putting other people's cases and not saying a word about themselves. And I suppose networking opportunities work well in person, in busy, noisy environments is often how it's set up for us. What alternatives have you found work well for you guys?
So for me, it's following my passions and my interests. For example, so my background was in legal aid, immigration work in a solicitor's firm, particularly asylum. When the Sudanese civil war kicked off and the British evacuated people with British passports, that included children whose parents didn't always have British passports, but they couldn't bring children to the UK, obviously, without their parents. So this left this whole cohort of individuals in the UK, brought to the UK by the British government, but with no immigration status and no plan. So I wrote an article about that on Free Movement, which is an immigration blog, which lots of practitioners read. That got picked up by The Guardian. That led to people contacting from charities about cases. And I didn't have to do a single networking event where there was noise everywhere. And I had to mask the entire time because I followed something that was interesting. And I think that applies to so many areas of law. If you've got a niche thing that you're really interested in and you get it published on a blog which people are looking at, then you can get yourself out there. If the idea of networking in person is a bit too much to deal with on top of all the other expectations. And similarly, I think if you are going to go to these networking events in person, the same rule can apply. Go to the ones that you really feel are the ones where you will either fit in, I say in inverted commas, or there's a shared passion or interest, which takes away some of the sort of masking that often has to be done. So I think, yeah, that's probably my top tip.
Great, thank you.
I might also suggest that if you have an interest as well, to do a seminar series that's something you're interested in. So I wanted to do something on AI because I was particularly interested in that and how it applies to education. So I said to Chambers, I want to do a 3-part series on that, and I ran a lecture series on it. And so if you have something that you're really interested in, then you're going to get the self-drive to do it. But also you can pick the format. So I wasn't going to do that in person, can't be asked. I'm going to do that online. And it really worked for me because I could do it at the middle of the day when I wanted to do it. I asked for it to be recorded so it could be available to solicitors as well. And then I was able to market it on LinkedIn when I remembered to repost it and stuff, and got my marketing team in mind. So things like newsletters, seminars, articles, things that are picked up then by the press. These are all different ways in which you can market yourself. It doesn't have to be that kind of old-fashioned in a pub. There's still some serious value in that. And sometimes one-to-one, go out with your solicitor after a case is a really nice and important thing. And I've certainly found I'm at the stage now where some of my solicitors are my friends, genuinely. And that wasn't the case when I first started. I would say that's quite normal. So yeah, nurturing those kind of one-to-one relationships, maybe just by picking up the phone, or you finished in a long con from a difficult case with your client, and you ask the solicitor who's in the case to like stay on a bit longer. I mean, I might spend a couple of minutes talking about the case, but then I'm like, how are your kids, or what do you think of the football or whatever? Because I know that we have a shared interest in that area, or we both have kids or whatever. And that is really valuable to me during the normal, ordinary hours of the day, rather than going to something out in the evening, because I'm knackered by 9 o'clock. So yeah, but everyone is different.
And the super way with that marketing is you play to your advantages, you play to your skill set, you show your niche knowledge, which is what everyone wants out of you as a barrister. And so it's all there for everyone to see, and then you can make of it thereafter what you will in terms of in-person events, I suppose, or meetings. Adam, anything you want to add?
I think that's very comprehensive. I think that's all really sensible stuff. To the point that I have nothing to add.
Let's see. We have a video that I referenced earlier, which I would like to share with you now. Someone super high tech is going to pop it on and play it for us all to view online and in the room. So it's from Julian.
Hello, and I'm sorry not to be with you in person. My name is Julian Norman. I'm a barrister at Goldsmiths Chambers, where I'm joint head of immigration and public law. I also sit as a fee-paid tribunal judge in the Mental Health Tribunal and as a recorder. Around the same time that I was called to the bar, I was diagnosed with what was then called Asperger's syndrome and is now known as part of the autism spectrum. In many ways, the bar is a very neurodiverse friendly career. So, for example, courtrooms, unlike open plan offices, tend not to have lots of competing conversations. Courtrooms tend not to be too bright or too noisy, notwithstanding the occasional air conditioner. There are very set or prescribed ways of saying things, and communication is required to be concise and direct. The work is self-directed. You have a good degree of autonomy over what you do and when you do it. And for me, law is very much my area of intense interest. So it is no hardship to me to be up late reading papers, for example. It's not perfect, but to me, the bar was an enormous relief, having come from an employed environment where there is much less autonomy over the work, and where the sensory environment was often very difficult to manage, although I wasn't aware that that was the source of my difficulties at the time. I thought everybody
Oh dear.
had those difficulties, and it was my fault that I couldn't cope with it. And of course, if you're employed, then seniority often comes with people management, which many neurodiverse people, me included, find very hard to manage. So it was with some trepidation that I considered applying for a part-time judicial position. I thought that I would be good at the work, but I had some hesitation. If I love what I do at the moment, and I'm good at it, why risk the upheaval of change and of course the harder diary management that comes with balancing work at the bar with work as a part-time judge. I'm very glad indeed that I did take the step of applying. It won't be for everyone. The trope that if you've met one neurodiverse person, you've met one neurodiverse person always applies. But I have found it is a role in which I can draw on my strengths, in that it is highly analytical, fast-paced in terms of thinking, but generally a calm environment. And of course, being the person in charge of the court means that if I need a moment to draw my thoughts together, I can do so. The admin is more of a challenge, as it is at the bar, but to deal with that, I fall back on the strategies I use in daily life as a barrister. I will leave you with a few of my own top tips. The first is one that I'm sure you will hear from others as well. Have a to-do list, whether that is on paper or an Excel spreadsheet, on Lex, on your phone. For me, it is absolutely essential, both in timetabling my day, sometimes reassuring me that I don't have to do everything right now, this moment, and also in terms of knowing when deadlines are approaching and when they need to be met. Secondly, find the right area of practice and the right set for you. Not every area will be for every person. There are some neurodiverse people who will thrive on the almost chaos. I was going to say that's perhaps not the right way to say it, but the very fast-paced environment of criminal law. And there are some who will simply be overwhelmed by that. There are some who will absolutely love sitting drafting documents, and some who would find that too much of a challenge in terms of needing novelty. If one thing doesn't work, don't assume that it's simply you being deficient in some way. Try something else. The third is to approach opportunities with curiosity. Don't write them off as not for you. I am absolutely delighted that I did look at that opportunity to apply for a judicial position with curiosity. It has turned out to be an extremely positive move. But with the caveat that you do not have to do everything. Just because something is available does not mean that you have to go and do it. My final tip is that a sepia background on a camera can help to hide a messy office. Have a week, everyone, and thank you for your time.
Brilliant. Thank you ever so much, Julian.
Best supervisor.
Super top tip. And that to-do list again aligns with the advice that we've received today in terms of having that framework of working and enabling ourselves to then negotiate matters that arise. We've had lots of questions online, so we're going to do our best to get through those, and we're very happy to take them in the room as well. I'm going to start by reading these out, and then hopefully you guys can assist with some answers. So the first person said, I have ADHD and suspected autism. I struggle a lot with perfectionism and rejection sensitivity. As a criminal barrister, I often face criticism or disapproval from judges and opponents. And because of my emotional dysregulation, my reaction to this can seem extreme. I get upset or may come across in a way which seems combative or challenging. Are there any tips for managing such social interactions?
That's a really good question. I struggle with that as part of my ADHD, thinking that I'm being criticised by a judge when actually they're just running out of time. And I'm trying to learn how to interpret what a judge is saying is not as a slight on me and my performance, but there might be other pressures or another point that they have decided they need to get to. But I think sometimes we think that we are becoming angry or showing that in court. And I've certainly thought that before. I thought, oh God, I was really pushing my point more than I needed to, or flapping, whatever. And then I've been told you were like a swan. And I'm like, how? And I get told this by chambers. I'm like, you look really relaxed. And I'm like, I am in turmoil in my head and I don't realize it. And I think recognizing that sometimes you are also countering a lot of that feeling of I'm showing my emotions too much by a huge amount of masking can also be relevant to that in courts. But I know that my criminal barrister friends have found that environment really tough, to be really honest. And so sometimes my experience of that has been through being married to a criminal barrister, is that being able to debrief with your mates after court and being really honest about how shit your day was has been really helpful for them, and sharing your war stories with other criminal barristers is very useful, because they're all usually in the same kind of boat with those experiences of what they explained, like being criticised or shouted at by a judge is unfortunately not uncommon in that scenario. So having that camaraderie of the criminal bar can be a really important part of that. I recognise though that going out after work and being at a pub is not going to be for everybody. So things like WhatsApp groups and being able to vent and talk to other people about it who really understand what it's like to be a barrister in that pressured environment is really valuable as well. But yeah, so I think my headline is, I understand what it's like to have that sense of emotional dysregulation, but it may not be showing as much as you think.
That's great, Alice. Thank you.
I think one of the great things about having just observed so many different judges in so many different courts and tribunals is realizing, or I'm going to carry that with me when I start on my feet in a week and a half, that it's really not personal. And I have RSD as well. So that question was almost, feels like it was taken from my mind, because it's something I think about a lot. But I've seen it in so many different circumstances, different things frustrating a judge, be it that time is running out, they need to move things along. whatever it is, and having seen that in all different courts and tribunals with all different styles of advocates, takes some of that personal feeling away. And I can remember, no, you've seen that it's not just you today, these things happen, and that helps a little bit.
We've also been asked about note keeping, and one of the inquiries is whether you have a view about recording court hearings and the assistance that that might give to those who struggle to keep a full note and miss relevant parts, which impacts their effectiveness. Of course, all court hearings you can't record for your note taking purposes. It's got to be typed or handwritten and what have you. Do you think that that's something that needs to be considered moving forward?
I've never fully understood why it's a criminal offence to do that. Maybe once upon a time it was to do with the privacy of the courts, but we have open justice now quite extensively. And there's technology now where you could just technically, I don't know what the law is on this, and I'm sure there is somewhere soon to develop, whereby you can have transcription software. So you're essentially keeping a verbatim note. It's a machine writing it as it should be. It's not recording, it's a type of recording, but it's not an audio recording. I don't know what the law is around that, so don't take any sort of legal advice. But that, I think we maybe are past the time where it's not acceptable to do that. It would be helpful for a lot of people. It's so hard to get a transcript on time anyway. When you try to lodge an appeal, you certainly won't get a transcript within 21 days. I think it would be very useful if that were rethought of, or certainly maybe nuanced, and maybe some exceptions baked into it for people who have that need.
Yeah. So we both at Neurodiversity and Law were thinking about writing to HMCTS about that, because there's things like, for example, on Teams, which is sometimes used for the civil courts, and probably in family law as well. Teams has auto transcription built in. It's not perfect because it's AI generated, but it also has auto captions. I put them on for every conference I have because my clients are often neurodivergent, and I find it really useful to just be able to keep track of the last few things that have been said. And it has that kind of built in, and the transcript will be stored afterwards, and I can see how that may be a bit more tricky, but auto captions disappear afterwards. So something like that shouldn't be a problem, even though it's technically kind of recording the hearing. So I think it might be that there needs to be a particular piece of software that would be approved, because I think there's some data protection issues that may come with it, and blah, 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 which is probably a bit more sophisticated legally than I can answer either. I don't know. But I think there is a conversation to be had about the fact that so many of my hearings are about 90% online, and it's not accessible in that sense, because we use CVP, particularly for the first tier tribunal, which is just a load of faces, and that's it. There's no other accessibility at all, apart from the occasional sign language or interpreter that comes in for those with hearing impairments. So I haven't really seen any other real adjustment to the software that we're using for online hearings. I don't know about in person. I suppose if you're in that kind of environment, it might be permissible to have an adjustment of somebody note taking for you, but then I recognize that may be an additional cost on the client. Some of the other later questions talk about getting support via, say, Access to Work, could involve a scribe or something similar being with you in those sorts of hearings, where you're not necessarily doing a recording, but you are getting a note of the hearing. A pupil can be very helpful for that as well, particularly good ones who can type really fast. So yeah, I think there's definitely a conversation to be had about it, and we're grateful for that question, because I think it's a problem that a lot of people are saying. It's
just occurred to me, I had an appeal last Friday, and there was a camera set up facing the advocates, and I thought, well, this is odd, what's this about? And it turned out it was being live transcribed with the permission of the judge.
Yeah, okay.
So I think it's frightfully expensive and only through certain companies, but it was being live transcribed there, and the transcript was available almost as soon as we got out of court.
Yeah. It was definitely available in Big Pub. I was available in the Independent Inquiry in Charles Sainsbury's. It was the same. Auto transcript was happening. So it's entirely possible to do, but there's a cost usually attached to it.
Yeah.
So I've certainly seen it in
transcriber on the other
commercial
end
stuff as well. Yeah.
So it sounds like there is the opportunity, but it's costly and it's going to be explored to see if we can roll it out more widely at a lower cost to assist everybody.
Yeah.
Okay. And I suppose we're nearly at a close. And one of the questions we've had is, for those on the panel diagnosed during your career, have you found that getting that diagnosis has helped your ability to understand what works for you and manage your practice? So I think Alice, you had
I was about halfway through.
Yeah.
Yeah, I mean, it's tricky because I think you're also working out how to be a barrister at the same time. And so many people would say when they're about 5 years in, they're
Yeah,
still
getting
working it
there,
out. And then when you're about 10, you feel like you actually are becoming a bit more of an expert in that area, and you get the kind of confidence that comes with that as well. But I think it's been meeting other people who are also like me and then learning from them about their strategies that has really helped. So because I knew I had what I had and I had it all along, then meeting other people and learning from them. And my friend sent me some tips the other day about particular time management software that she uses. She's also got ADHD and is that another set. And it was just really helpful to share those ideas. So I think my diagnosis has helped me to find help, if that makes sense, and signposts to the sorts of things that I can trial. And also that kind of forgiving community that can come with that as well. So like particularly in the Reddit communities as well, in particular, and some Instagram, it's a lot of forgiveness of those things that you might find difficult. And that's very valuable, I would say. The things that you might have thought when you're in your 20s or teens that were like just hard for you and you were really rubbish and you have that negative self-voice, learning actually as an adult that these aren't things that you have to have as a negative self voice. And yeah, I think that that's the most valuable part, is being able to meet the community around it.
Yeah, I don't have much to add. I think the answer is yes. For me, it's helped navigate the pupillage process, the applications, and going forward, it helps me to articulate what suits me. So in short, yes.
And keeping that conversation going, I suppose that helps us come suitably to an end at 7 o'clock. As we said, we have another question in the room, which is great. Let's ask that.
Thank you. Firstly, just thank you for everything you've said. It's hugely encouraging to hear you speak this way. Building on what you were just saying, Mr. Coverley, my partner and I are both aspiring barristers who have some neurodiversity, and as we've gone through that process, encountered many other people in a similar situation. You spoke just now about how helpful it's been and how valuable for people, for you to have those people supporting you and being forgiving about these things. What else can people who are in this situation do to help each other feel supported as they go through this?
Yeah, I mean, so for example, on Friday, we've got a social for neurodiversity law. I can't emphasize enough how great it is to meet people who are part of your clan, part of your tribe. Like it means the world to me to meet other people who are just like me. And it's not that common that happens. And when you do, it's really valuable. And I think that helps, because then you don't feel as weird or alone or strained or messed up or whatever, because you're just an ordinary person, but you have a different kind of brain phenotype. And I find that very useful to meet other people. So we have a social with Neurodiversity Law on Friday. We'll do some social media about it. It's in, you'll know better than me. I can't
It's in 38 Bowlby Street, Chaos. Come shop, please come along 5 till 8.
On Friday, it's Spitalfields, isn't it?
Yeah, just near Spitalfield Markets. Nearest tube is Liverpool Street.
Yeah.
But please all come along, neurodivergent or otherwise. It's a friendly space.
So that I would say that's number one, meet other people like you. There's also mentoring programs that are being rolled out. I've seen a couple of new ones via the Legal Neurodiversity Network is working with one. I can't remember the name off the top of my head, but they post about it a lot on LinkedIn. So they match you up with senior people who are in the role, or even junior people, but people who are kind of a few steps ahead, got a diagnosis already, have worked out what reasonable adjustments will work for them, so give you ideas. So I think sometimes it can be really hard to be like, I don't know what to ask for. I don't know what will even work for me. Like someone told me to get a notebook or whatever. Okay, but I don't, you know what I mean? Like having ideas to trial can be really valuable. The third thing is that, so in my field, I work with a lot of experts in particular areas of special educational needs. So speech and language therapists, occupational therapists, educational psychologists, psychiatrists, psychologists, and they are also generally meant to give you advice on different things that you might find difficult as a neurodivergent person. So at the end, give you a bit of a prescription of these are the techniques that would work for you based on my assessment of you, not just off the shelf stuff that works for most autistic people in the 90s. You know, something that's actually really bespoke to you is really valuable as well. So I recognize that there's a kind of financial barrier to getting that kind of support and advice. But I would say that's available to people to look at. Occupational therapy is specifically helpful, I would say, for that.
Great, thank you. Any other questions in the room? No. All right, well, thank you everybody for attending. We're really grateful to you all, those of you in person and also online. It sounds like a great event on Friday if you can join, and we'd like to hope that this conversation will continue and that we'll do future events throughout the years to come to keep learning and learning from one another and sharing ideas which enable us to navigate the world better. Thank you so much. Good evening.
Thank
you.
Thank you again to all of our speakers. If you are here in person, we do have a